I thank the delegation of South Africa for its presentation. I
invite the next delegation, Algeria, to address the court and call Professor Ahmed Larabat to the podium. Sir, you have the floor.
Mr. President, members of the court, I have the honor of presenting the oral presentation of my country, the Democratic and People's Algerian Republic, as part of the advisory proceedings pertaining to the request of the UN General Assembly of the 30th of December 2022. I shall do this with the benefit of the following few remarks. The two questions posed by the General Assembly successively pertain to, I quote, the legal consequences of the persistent violation by Israel of the right of the Palestinian people to self-determination, of its occupation, its colonization, and its prolonged annexation, end of quote, and I quote once again, the consequences that arising from the policies and practices of Israel on the status of occupation and the legal consequences that flow from them for all states and the United Nations organization. The key word of the UN resolution is that of occupation. It is abundantly cited both in its preamble as well as in its operative paragraph, inter alia. It is the only term to be found in the two questions posed by the General Assembly. Such an importance should come as no surprise, because the prolonged occupation of Palestinian territories is the central point of their situation that has considerably deteriorated in every respect these past few months. It is the reason why Algeria will begin by addressing briefly the non-existence of compelling reasons not to respond to the General Assembly's request. That's the first point. And then it will focus on reviewing the manifestation of prolonged occupations of Palestinian territories and their consequence on its legal status. Second major point, this examination leads to the acknowledgement of a continuous, gradual and extreme violation of the rules and principles of international law, underscored by the UN General Assembly resolution. And lastly, final point, the legal consequences for all states and the Organization of the United Nations. On the non-existence of compelling reasons, in substance, four arguments were rehearsed. There's first of all the principle known as the circumvention of the absence of consent to the court's jurisdiction. First point, the existence of factual evidence. Second point, the conflict that exists between this request and the existence of a negotiating framework. Third point, and lastly, the absence of aim and purpose of the request. Algeria recalls that these have been constantly discarded by the court, notably in its opinions of 2004 and 2019, to mention but two of the most recent ones. There's no circumvention of the absence of consent to the court's jurisdiction. constantly invoked in advisory proceedings, notably in that pertaining to the unlawfulness of the construction of the wall in 2004. This argument has quite constantly been discarded by the court. As the High Court declared on a number of occasions, the possibility of the existence of a concomitant bilateral dispute to an advisory proceeding is in the nature of things. In this regard, it would be hard to find further reasons that might legally justify the reiteration of this argument. Second point that we can term the factual question. This argument is also a classic one, regularly put forward to invite the court to refuse to accede to a request for an advisory opinion. The court has always refused this. It notably declared in paragraph 58 of its 2004 opinion that, and I quote, "The circumstance that others may evaluate and interpret these facts in a subjective or political manner can be no argument for a court of law to abdicate its judicial task." End of quote. On the third argument, that pertaining to the existence of a negotiating framework, another major classic in this regard, the existence of a negotiating framework put in place by the Oslo Accords was once again put forward in order to invite the court not to accede to the request of the General Assembly. The court took clearly a position in paragraph 53 of its 2004 opinion by declaring that participants to the proceedings expressed in this regard divergent views, and the court, and I quote, "cannot regard this factor as a compelling reason to decline to exercise its jurisdiction," end quote, on the absence of aim and purpose of the request of the General Assembly. This argument, that of the absence of aim and purpose, is not new either. Here again, the court should not accede to it. We can notably refer to paragraph 60 of its advisory opinion of 2004, where the court rejected it by stating, and I quote, "As it emerges from the court's jurisprudence, advisory opinions serve to supply the organs that request the elements of a legal character that are necessary as part of their activities," end of quote. It added in paragraph 62 that, and I quote, "the court cannot decline to answer the question posed based on the ground that its opinion would lack any useful purpose. The court cannot substitute its assessment of the usefulness of the opinion requested for that of the organ that seeks such opinion, namely the General Assembly," end of quote. At the same time, that brings to an end the first part of the presentation. Part two, the manifestations and consequences of prolonged occupation of Palestinian territories. And firstly, observations on the occupation of Palestinian territories. It's an ambiguous notion, if ever there was one, because located in theory at an intermediate stage between war and peace, the notion of occupation found its basis in Article 42 of the Hague ruling of 1907, whose customary notion is not contested, as the court recalls in paragraph 89 of its opinion on the construction of the wall. Without dwelling on the legal regime of occupation, it is important to highlight with a broad brush its most fundamental aspects. In substance, occupation was originally devised in a context that needs to be underscored, in which there did not yet exist the principle prohibiting the use of force. It was devised as a temporary regime in which the occupying power, as we know, does not exercise its sovereignty. One may, inter alia, underscore that it was devised to manage temporary situations between the end of hostilities and the conclusion of peace treaties. It would almost suggest a peaceful relationship between occupier and occupied, regarding which the idea of prolonged occupation was totally inconceived by the drafters of the time. It's the reason why the right of occupation addresses neither the question of its prolongation nor, with stronger reason, that of its permanency. The multiplication of armed conflicts has brought about new forms of occupation. The realities are far more complex, and the state's contemporary doctrine, as the ICRC, regularly question certain deficiencies of the law of the years 1907 and 1949. The Palestinian situation is a striking illustration of the violent contrast that exists between theoretical appearances that have just been sketched out with a very broad brush and a reality. Algeria considers that the situation created in 1948 and continued to shows up starkly the misuse and abuse of the concept of occupation by Israel in occupied Palestinian territories. Israel's goal is to reach a point of no return in order to discard all possibility of the creation of the Palestinian state. This objective has several forms decided on the basis of situations specific to each part of occupied Palestinian territory. That's to say, East Jerusalem, the West Bank, and the Gaza Strip. And so, occupation is becoming, if it hasn't already become so, an avatar of former legal techniques that expressed, each in their own way, the right of power. Second point, after those brief observations, the colonization of East Jerusalem and the West Bank and the situation in the Gaza Strip, first corollary of prolonged occupation. In the three parts of Palestinian territory, we find the same policy and the same practice that we can summarize with the formula of fact against law. In East Jerusalem, with the war of 1948, the UN plan for partition, Resolution 181 by the General Assembly, was first stopped in its track, and the fait accompli illustrated by the occupation of the western part of Jerusalem by Israel in violation of Resolution 181, at the same time by the adoption of legislative and administrative measures, including expropriation. After the 1967 war, Israel began to apply its domestic law with the application, but not exclusively, the adoption of two laws adopted on the same day, 27th of June 1967. This policy will be strengthened even further with the law dated 30th of July 1980, making Jerusalem the capital, quote, full and reunified of Israel, but in fact it should be characterized as de jure annexation. I'll return to that. The law of 27th of November 20 amended it with the view to consolidating it even further, and I quote, to prohibit the transfer of all form of government power, end of quote. This law of 2000 was once again amended in 2018 to strengthen its scope even further. So, fait accompli on the one hand, followed by the establishment of Israeli legal rules in the West Bank. Here again, two successive phases. Planned military occupation is followed by the beginning of colonization with the building of hundreds of settlements and the displacement and confinement of the Palestinian people, as well as the destruction of their buildings. The most striking feature in the West Bank resides in the spectacular increase in the establishment of settlements between 2012 and 22. The numbers went from 520,000 settlers to 700,000. That's quite dizzying a figure. And the consequences were of several orders to move the human beings and also to displace as well as confine the Palestinian people. And last but not least, the construction of infrastructure and the exploitation of natural resources. All historians of colonization stress the compelling importance of the dispossession of land in establishing and accelerating colonization. That of Algeria is a particularly striking example. As to Gaza, third point, the Israeli withdrawal of the Gaza Strip in 2005 was immediately followed by the blockade and 4 large-scale military operations, of which the latest is ongoing. How can we focus on the fate of Gaza without evoking the current situation? The facts, first of all, in truth, they speak for themselves, and the images speak volumes. Res ipsa loquitur. Next, figures that are overtaken the day after their announcement, over almost 30,000 dead and twice as many wounded, the destruction of almost half of all essential infrastructure goes hand in hand with famine, lack of water, really below the minimum level of necessities. The situation of Rafah is the latest preoccupation of the international community and international organizations. Its gravity is due to the latest plan by Israel to launch a large-scale military operation of a civilian population of 1.4 million people, stunned and buffeted a Gaza Strip that had devastated for a long time. And paraphrasing Cato the Elder, obsessed by Carthage, whose leitmotif was the term Carthago delenda, as we can say today that Gaza destructum est. On annexation. Annexation is the second corollary of prolonged occupation, the first being colonization. The legal consequences stemming from the dramatic developments of prolonged occupation raises the question of the development of the latter. It's not a new question. It is evoked, sometimes suggested, sometimes frankly considered after every war, notably by Israel. But over and above that, the situation of prolonged occupation since 1967 imposes it inevitably in the debate. In its resolution of the UN, the General Assembly expressly referred to the impact of Israeli policies and practices on the legal status of occupation. Regarding the court's jurisprudence, Algeria would recall that in its advisory opinion of 1950 on the international status of Southwest Africa, and as I quote, where it was expressing itself generally on the mandates, and I quote the court had underscored that two principles was deemed as of paramount importance, and I quote, that of non-annexation, paragraph 131 of that opinion. Algeria recalls next the paragraph 121 of the opinion on the 2004 war. The court felt that the construction of the wall and the regime associated thereto creates on the ground a fait accompli in inverted commas, creates on the ground a fait accompli that might well become permanent, in which case, and notwithstanding the official description that Israel gives of the wall, the construction of this wall would be tantamount to de facto annexation. In end of quote. In this excerpt, the court considers, first of all, that the construction of the wall and its legal regime are fait accomplis. It then refers to the possibility of their permanency. And it concludes by using the conditional that the permanence would transform the occupation regime into de facto annexation. In other words, it's the permanence that conditions the passage from occupation to de facto annexation. So, inevitably, this refers to the question of the duration, and we know, as we saw earlier, international law of occupation remains silent. The notion of permanence must be assessed in light of the factual context of the situation, 2004, that the court set out. And in paragraph 69 of the opinion, the court referred to structures built or under construction, specifying further, and I quote, that the Israeli Council of Ministers on the 23rd of June 2002 approved the first construction phase. That's to be found in paragraph 80, and that the construction of the wall was accompanied by the establishment of a new administrative regime, end of quote. And so one can better understand the prudent wording of paragraph 121. In 2004, it was still permitted and legitimate to ask about the completion of the construction of the works, given the date, 2004, and a possible felicitous outcome of the negotiating process. Such prudence can, with difficulty, still be applied when the construction of the wall has continued and the regime associated with it was consolidated. This situation has wall and its legal regime. Similarly, it is possible to question and ask about the legal regime of the West Bank, that its prolonged occupation has been ongoing for 57 years, and the West Bank prolonged occupation with its construction of settlement and destruction has led to de facto annexation. It is in the nature of things, alas, that colonizations, destructions, constructions are not destined to be temporary. In this regard, we can recall the conclusions of the International Independent Commission tasked by the General Assembly to investigate the occupied Palestinian territories in September 2002 that noted acts tantamount to annexation. The continuous, gradual, extreme violations of relevant international law, an obstacle to the creation of the Palestinian state. Three areas to briefly address here. Firstly, the violation of the right to self-determination, an erga omnes paramount rule. One could have recalled the various stages of the legal development of this law. It was done so on several occasions in the written submissions, the written observations, and up until yesterday in Palestine's oral presentation. Both the Charter as well as Resolution 1514, 1804, and the jurisprudence of the Court of its successive opinions of Namibia in 71, Western Sahara in 75 contributed to this, and of course particular contribution must be on East Timor of 1995, because that's where the court considered that the right of the people is enforceable erga omnes. No need to stress that the International Law Commission enshrined the right to self-determination amongst the imperative laws at the end of its work devoted to the imperative laws in 2019. Extended prolongation, the source of unlimited international law and international human rights law. Israeli policies and practices violated the most fundamental aspects of these two branches of international law. It would truly be pretentious to have us believe in the remaining time to give a broad spectrum of all these violations. I think we can refer here to the previous submissions by Algeria, but also those of Palestine, including those delivered yesterday. On the legal consequences now, for Israel, it is under obligation to put an end to violations of international law, has a duty to repair all the harm suffered by the Palestinian people, and also under obligation to deliver on all the obligations that are violated, and to repair the harm, and for the other states not to recognize the situation created by this, not to render assistance to Israel. A number of recent events that show the question of not rendering assistance to Israel is beginning to take shape for the UN, for the General Assembly and the Security Council. The aim is to increase the decisions. In general conclusion, Mr. President, ladies, judges of the court, Algeria is profoundly convinced that impunity is the fourth law of oppressors. Your duty is to tell them there is a law and this law must be upheld, that this law is not a law of vengeance but of justice. It's in that spirit that Algeria repeats the request made in its previous submissions. Thank you, Mr. President, members of the court.
Excusez-moi, je remets